If you have a debt collection lawsuit or you have debt collectors coming after you, you're going to want to watch this video. The reason why you're going to want to watch this video and pay close attention to what I'm going to share with you in this video is because it's going to help you get your life back to normal. It's going to help you protect your money. It's going to help you protect your reputation. It's going to help you not have the anxiety, the worry, the stress, the sleepless nights, all of that stuff. I'm going to help you be able to deal with that with the information that I'm about to give you. Now, because number one, I want you to feel good about yourself. And if you feel good about yourself, you're going to be able to take action. And once you know what action you need to take and you feel good about yourself, good things are going to start happening for you. Now, I want to answer something real quick for some people. I read the comments, but I got to say it. You know how I am. I'm going to say it the way I say it. I'm just going to put it out there. Some of you be like, Steve, get to the point. Well, let me tell you the reason why I don't get to the point. And I'm going to tell you a story about why it is important for you to watch the video, not because of the video views, because of your mindset. And I got a good example of it. I got a great example of it that's going to blow your mind. I'm about to tell you right now. Debt collection company is suing this individual. They're sending the letter, the demand letters. They send the summons months later saying, you've been summoned to court. We're going, they put their summons together, all of their allegations, all of that stuff. Send it to them. The person signs for it. Guess what? This individual is scared. They got anxiety, can't sleep. They're worried. Are they going to lose their money? Like all of this stuff popped up in their mind. Guess what? This individual used to work for a debt collection company. They used to be on the phone calling people like you, calling people like me in the past when I had my credit and debt issues, calling us, telling us what they are going to do to us to get that money. And this person told us straight up, I know what they can do. I know what they can't do. I know what they try to hide from us. And guess what? That person came up with emotions first. And that's why I make my videos the way that I make them, because no matter what, when something is presented to you and you are not certain about the outcome, you're going to default back to your emotional feelings, what you went through in the past, what you think you're capable of, your resources to be able to deal with it, what you're going to have to do and what you're not going to have to do. All of that stuff is going to hit you, and it's going to be like a split second. And that's why we end up making emotional decisions on stuff instead of really thinking through and looking for logical solutions. It's because we default to emotion first. And I know some of you, when I make my videos, you're already past the emotion and you're ready to get started on this stuff. But I'm telling you, when you start to do the technical stuff that I tell you about, you are still going to dig back to try to find certainty. And so if you feel good about moving forward first on the inside, you need to use that good feeling on the inside. Calm down those emotions and understand emotionally why you are moving forward. Because even when I tell you what to do on a technical level, you are going to dig back deep and you're going to ask this big question. The three big letters. The three letters that we always ask people when they tell us something that we didn't know about or tell us to do something is you're going to say why. So when I tell you the technical parts on how you can beat an original creditor lawsuit or a debt collector lawsuit. And I have an example right here. One, the lady was screaming on the phone. She was on the customer service. I could hear her. My desk is about 15 or 20 feet away from my customer service team's desk. And I heard her on the phone. She was screaming. She was shouting. She was saying, praise the Lord, all of this stuff. And I said, what happened? And he said, she beat the original creditor lawsuit. $7,227.08. Tell me how you would feel. See, tell me how you would feel. Protect your money. If you lose $7,227.08. If you win, zero. And don't be on my channel talking about you trying to run for money and all that stuff, because I expect this young lady to recover and build up new credit and protect it. And the companies that give her credit, she will pay them and they will make money, and they will make money off of her, and she will have a good life for learning from this lesson, because we all make mistakes. So don't be on here talking about people don't want to pay people and all that stuff. I done went through it on both sides. I've had people who make good money not pay me for one of my companies. Hell, I've had some people with the credit repair shop not pay me. But I don't lead my life that way thinking that that's all that person is. People go through stuff. But when you are being sued, when you have debt collectors coming after you, when you have all of this stress, anxiety, worry, all of this stuff hitting you, you default back to your emotional feelings, and all of that stuff comes at you in a split second. That's why some people are paralyzed. Some people say they're working on their credit, and it's 5-10 years later, still working on their credit, because they haven't made a decision on the inside that no matter what it's going to take, I'm going to get the job done. And they're always worried about the time it might take to get it done, rather than worrying about, let's just start getting it done. And whatever the amount of time it takes, it doesn't matter, because the time is going to pass anyway. So now let's get to it. Clap your hands. I want you to drink some water or whatever. I'm going to have a drink of my coffee. I'm excited. We had some other victories too, but this is one because she was screaming. She's going to make a testimonial video, and I hope she's just as excited with that testimonial video also. But it's been a good week. It's been a very good week. Last week, the week before, left and right, either dismissed or just straight up winning, or judgments being overturned and dismissed by the plaintiff attorney. So no matter what, if you're being sued by the original creditor or debt collector, no matter what, this is what you got to keep in mind. So for the purposes of this video, so we don't go so long and have the complaints, even though I don't really care about that, we're going to stick to it with original creditors. When you are being sued by the original creditor, and original creditors are starting to say, hey, rather than selling that loan for pennies on the dollar, what we're going to do is we're going to keep them. Go get that law firm and that we're paying this retainer for. Who are they affiliated with in that state? Okay, since we're already paying a retainer, have them go do the work and sue them, and we can get a judgment and get all the money plus the fees and the court costs and the attorney fees. That's their thought process. Different, like I used to have a short list. It was Discover, Barclays, American Express, and Capital One. I had a short list of companies that would be like, we're not selling it. We're not selling it. We are going to go after the money ourselves. We're going to get all of it. So they didn't want to pay payments that way. We're going to get payments this way. And if they live in a state that you can't garnish, get rid of garnishment to go straight, put the bank's hand right into the bank account, take the money, and every time the paycheck goes in there, we just dip right in there. Oh, they moved to another bank, do the skip tracing that Equifax and TransUnion offers. So when anyone opens up a bank account, all you have to do is skip trace it, and boom. Reason why they ask Social Security and name and all of that stuff, even with Cash App and all of those, be very careful. Be very careful. All of that stuff is now being recorded, and you have given your permission to have it recorded. So they will dip in you wake up in the morning, money is gone out of the account. So now let's talk about fighting, because if you don't respond to the debt, to the summons, you're already 50%, 75% lost. Unless you live in a state that says you have to be served, like you have to be served, and that's dwindling down. They could just say we attempted service, and then you're going to get that default judgment. So just because you stop don't mean that they're going to stop. So now how do we beat an original creditor debt collection lawsuit? The way that you beat an original creditor debt collection lawsuit is to understand from the beginning is that you have a right, according to the Fair Debt Collection Practices Act. Any debt collector who collects debt for others must follow the Fair Debt Collection Practices Act. What that means in short, for you fast food credit repair and get out of debt people, fast food, which I admit I'm one of the fast food people too. I had to slow myself down. And when I say fast food, I mean where I want to get it fast, but I've learned that you got to slow it down so you can internalize it, so you can move forward the right way. Is that according to the Fair Debt Collection Practices Act, debt collectors who collect on the behalf of others, when they say others, where they don't buy the debt, they are collecting on the behalf of their client, that they must abide fully by the Fair Debt Collection Practices Act. That is a fact. So with that understanding, you could simply go and look at the Fair Debt Collection Practices Act and look at what they must provide. But this is what makes the credit repair shop different, is that you cannot just quote the way that they have it on the Fair Debt Collection Practices Act. If it was like that, attorneys would all be equal. But you got Johnny Cochran, you got being big with with stuff that happens. I just saw him on the news. You got Shapiro. You got I don't want to leave. There are lawyers and then there are lawyers. There are companies and then there are companies. We're a company. When you have a company, you dig deep in the details and you understand how to describe. So what you're trying to say, sorry, I'll back up. How to describe what you're saying. So when you put something about the privacy, so we'll just run the list. The privacy. You're thinking that, okay, well, if it's the original creditor and they give my information to the debt collector, then they have a right to see my private information. Remember Family Feud? They had that X on Family Feud. That's what you would have right there. You have a right to request that information to see how they're able to get access to your personal information. You have a right to that. Now, I've had people say, well, Steve, I asked for, information on why they're able to have access to my personal information. It's because you didn't describe it in a way that would make them feel as if they had to give it to you. Have you ever heard of court cases where people were in court and they said that either my lawyer didn't say it a certain way or they didn't even ask for it? Most of the time people didn't ask for it, but even some of the times if you don't ask for it the right way, think of it like a child. Your child don't just come bump up to you and they just ask for stuff from you. Your child learns there's a certain way that they have to ask, a certain way, certain emotion, all that stuff. Now, I'm not talking about being that way for this, but you have to describe it to where they're going to have a logical, in a way, it's like something that they just automatically are willing to do because of the way that you ask it. So private information, you have a right to know how and to get how they have permission to even see your private information. And that is to the law firm that is actually viewing your information, because that's in the Fair Debt Collection Practices Act. The next thing is to get the full account number on the debt, because they'll usually have all these X's and then they'll have 4 digits and they'll say the last 4. Well, you have a right to get the full account number, because what if you have multiple accounts? You need everything that you can get to authenticate the account. So you got to say it a certain way. If you don't say it a certain way, it's just going to be disregarded. Or if you don't say it at all, it's going to be disregarded. And that's in the Fair Debt Collection Practices Act. They don't say it that way, but you can use the Fair Debt Collection Practices Act to be able to get it, because you have a right to have a full verification and validation of debt. How can you validate any debt if you don't have a complete account number? How can you? On your statement, did it have XXXX? On your credit card, did it have XXXX, or did it have a credit card number? The other thing is, they need to prove how they came up with the claim amount: payments, credits, interest rates, disputes, any communications, signatures, pins, approving the charges to add up to the amount that they have claimed. Also, you want to make sure that if they purchased a portfolio, or if the debt collection attorney who is working for the original creditor, that they're looking at that, because it's going to be in a portfolio. Even though it's not sold, they're going to still batch up all of those accounts. They're not going to just leave them on the performing accounts books. So you're going to ask them, is the information that they've received, now they might say, well, we only received your information. More than likely, they received a portfolio of information, even though they didn't buy it, and they started picking and choosing the accounts that they're going to go after people on. They're not going to just be cherry picking, or they're not going to just be getting one at a time. The firm is going to handle as many cases as possible in that area. The next thing is, did they file a 1099-C? And you need to ask this the right way, because, and we've heard this from time to time, and you need to call the IRS. If you have an original creditor who has not sold your debt, you need to call the IRS to make sure that a 1099-C cancellation of debt was not submitted in your name, because it could take up to 1 to 2 years for that to get back to you. And you have a right to know that, to get it on record if you ended up getting a judgment and later they came and they showed that the debt was written off in a 1099-C, the entire amount that they're trying to claim that you owe. That would void out that judgment. You would have evidence of it. The next thing is the chain of title to prove ownership of the debt. There's always this gray area. Does the debt collection attorney own the debt, or does the original creditor own the debt? I've seen where lawsuits were written in the original creditor's name and it was actually owned by a debt collector. Or I'll see where it has a debt collector and it'll say assignee. They're using these terms because they want to confuse you. They want to confuse the court. You have to write and this is in your affirmative defense, your response to the court summons, you got to write it in a way to get them to want to reveal that information. You have to say it in a way to make them think logically. If we don't get this to them, it's going to look like we're hiding something. The next thing that you need to ask for is you have a right to, according to CFPB guidance on debt collection lawsuits and a recent update on what they require debt collectors or those who collect on the behalf of original creditors is to give you 18 to 24 months of statements showing all of the charges to equal the amount that they're claiming that you owe. So not just a few statements. Remember, if you don't ask for it, they're going to proceed with what they got. You got to look at those documents. If those documents don't make sense to you, you describe that in your affirmative defense, that these documents that they presented don't even make sense. So how could they make sense to the court? How can they make sense to them? Because the way that they've been used to it, they just throw some documents out there and hope you don't do nothing. And if you don't do nothing, they get the judgment, even if you're sitting right there in front of them. The next thing is you want all the statements and communications that you had with the original creditor. So even if it's with a debt collector or with the original creditor and a lawyer is suing you on behalf of the original creditor, you still have a right to get all the copies of statements, communications regarding the alleged debt, and any notices of default or accelerations of that debt. Everything. You want to, just think about that. If you are asking for things that they should have access to, have already proven already have gotten provided by the original creditor, and they don't have it, and then they went to court without that information, what do you think that attorney is going to do if they don't get that information? It's been requested, but it's in your affirmative defense that you need that information to be able to move forward with the case to make sure that this is appropriate. What tends to happen is what happened with this case is that the original creditor's law firm put in a motion to dismiss the case. The next thing you want to do is you want to get the dunning letter from the law firm that is representing the original creditor. Even if a law firm did not purchase a debt, they still are required to send you a demand letter to pay that debt. They cannot just skip right over to the lawsuit. So you have to have the opportunity to dispute what they're demanding, and that's in that dunning letter. And what you would do to round it off in your affirmative defense is that you're requesting the documentation from the original creditor, who is the plaintiff, and then you're also requesting the documentation from the debt collection attorney. This is where you are putting them on notice on, like, hey, you have a requirement according to the Fair Debt Collection Practices Act to get all of this information. You're standing here in court and you don't even have all the information. So that information that I just gave you right there is good enough, based off of the documents that client gave us, to win a case against an original creditor who was suing for a debt for $7,227.08. If you need help with the debt collection lawsuit, immediately go to my website, thecreditrepairshop.com, www.thecreditrepairshop.com. In the live chat, post your summons. We'll review it, and we'll let you know how we can help. Original creditor or debt collectors, tell us everything that you know. Tell us your situation. Don't hide anything from us. We're not going to tell them anything. That's going to help us be able to help you better. If you have debt collectors coming after you early in the game, use my 3-pack of letters: statute of limitation, cease and desist collection activities letter, and debt validation letter. I ask for a donation on those, but they can save you time, money, and frustration, and also avoid you getting to this situation. And even if you do get to it and they did not get you the documentation from that, it can stop them from being able to proceed with that lawsuit, because you will have proof that they did not respond to your request, which they are they have to do that. They are required to do that according to the Fair Debt Collection Practices Act. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different so you can see my 8-point validation process. And I think I'm going to change it to reliable credit repair. Honest and reliable, because it's no overnight success. It's going to take time depending on your situation, but we will get you in a better place. You get your mindset thinking in a better place. We do the technical stuff to get you in a better place, which is the credit repair process. If you need your credit reports and scores, go to the website, your3scores.com. Links are below this video. Thank you for your time. Subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.